and Belacqua Mineral Water. In a twist that could bring an immediate end to the 2020 election petition hearing, the chairperson of the Electoral Commission today announced she does not intend to enter the witness box. Now, this means Jean Mensa will not give an oral testimony and will also not be cross-examined by lawyers of John Mahama. The surprise announcement came on the day when lawyers for Mr. Mahama, who has petitioned the Supreme Court challenging the outcome of the 2020 elections, had their last witness, Rojo Metonunu, cross-examined by both lawyers of the EC and for President Akufo-Addo. Court correspondent Joseph Akable joins me in a studio with details on another day of dramatic events at the Supreme Court. Joseph, what a day this was. Now, did the lawyers for the EC give any reason for their announcement today?
Yes, Justin Amenuvo, who is lead counsel for the Electoral Commission, did indicate that after listening to the case of the petitioners, they are of the view that it is no longer necessary for them to call witness to lead further evidence because they believe that a case has not been made for the reliefs that the petitioners are seeking. And so he said the rules permit for, in such instances, for the person in this instance, the respondent, to exercise a right not to allow his witness to enter the box.
It's our submission that in view of the evidence led by the witnesses of the petitioner and our cross-examination so far, my lords, it is the first respondent's case that we do not wish to lead any further evidence, and therefore we are praying that this matter proceeds under Order 36, Rule 43, and CI 87, Rule 3E5. And we hereby, on that basis, close our case.
So the first respondent closed their case today. So Madame Jimenez announcing today through her lawyers that she will not be entering the witness box. However, she has a witness statement already before the court.
Yes, it was part of the January 20 orders that the court gave, asking the parties in the case to file witness statements. And so the EC chairperson did file a witness statement, and it was an issue of concern for some of the members of the panel.
Mr. Menuvo,
yes, my lord.
What then happens to your witness statement?
Well, my lords, under CI,
you file a witness statement.
Yes, my lords.
And the witness statement is supposed to be subjected. It's going to stand as your evidence in chief.
Yes, my lords.
And therefore, it's supposed to be subjected to cross-examination.
Yes. My lords, under CI 87 Rule 3E5, where if a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lords, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not leading any further evidence. We are not calling evidence.
Did the rules say the court can treat it as hearsay? So any party?
No, the party, a party, not the court.
So
sorry.
not the court. Yeah.
The other side can treat it as such.
So that is his explanation when it comes to the witness statement. We'll hear from Mr. Chachikata shortly, but I'm curious, Joseph. So that is the position of the Electoral Commission chairperson. What about the other defendant in the matter, President Akufo-Addo?
We know that the other respondents, i.e. President Akufo-Addo's side, they also filed a witness statement. Peter McMenu, who was given a power of attorney by President Akufo-Addo to testify on his behalf in this case, put in a witness statement. And so Mr. Akotampa, who represents the president's legal team, did indicate to the court that they also hold the view that the petitioner who has the burden of proof to discharge has not carried out that task. And so they also do not intend to call Mr. McMahon into the box.
I see. So what it means is that both the defendants, President Akufo-Addo, EC chairperson, they don't want to proceed further. I mean, they don't want to, put any of their witnesses.
But they are asking the court to proceed and deliver judgment on the basis of what has transpired so far.
I see. So in other words, the court, if the court agrees, will simply say, we've come to a close. Next time, come for judgment.
Yes.
Before that could happen, though, Chachi Chikata has a lot to say on this, right?
Yes.
He disagrees that they can do what they've done today. Both defendants can indeed opt not to put their witnesses in the box.
He did indicate that as far as he is concerned, once they elected, i.e. by coming in to decide that we are going to file witness statements, and they file those witness statements, it is important that they go into the box to have those witness statements subjected to cross-examination. But a number of the judges had questions, and Mr. Chikata provided answers.
Well, listen to this very fascinating exchange between Mr. Chikata and the judges.
Counsel for the first respondent does not have it open to him to take the course that he just proposed to this court. Order 36, Rule 4.3 that he refers to specifically says where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement. My lords, what this provision says, where they elect not to adduce evidence. And what I'm saying is that the election that they made to submit the witness statement to the court is a clear indication that they made an election to the contrary.
Assuming we were not dealing with witness statements and we were giving oral viva voce evidence, when would you say that a party has elected not to give evidence?
At the case management stage. If the party at the case at the case management stage, the party may, otherwise the case management stage is meaningless.
No, Mr. Gibbs, a point of correction. The orders for witness statements is made at the application for direction stage and not at the case management.
The orders
it's made on the order 32.
Yes,
the application for direction stage.
But my lord, that is the situation here is different from the pure High Court situation.
Are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6. Can't you say that?
My lords, you can say that.
Yes, please.
My lords, you can say that, but that is not what is dealt with in Order 36.3.
So if the plaintiff closes his case and the defendant realizes that the case the plaintiff has made has no substance or does not establish the reliefs he is claiming, and there will be no need for him to testify, he can tell the court that he will not testify, and then he will be put to his election. Whether if the court rules in respect of his application, he will still testify or he will not testify.
My lord,
that is the procedure.
My lord, with the greatest respect, that is not the procedure under our rules.
It's a settled practice.
My lord,
that we adopt. So are you saying that
my lord,
a party cannot say that I will not testify, judge the case according to the evidence you have?
My lords,
because you cannot compel anybody to testify.
My lords, with the greatest respect, my lords, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. Under common law, the authorities are clear that that process that your lordship just described is not available.
Mr. Chikata, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My lord, that is not what I'm suggesting.
Mr. Chikata, you are aware that at case management stage, nobody knows the evidence that the others bring. It is after case management audits that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity. I believe that.
Mr. Chikata, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry. My lords, this is new territory. I mean, I have to think of it because frankly,
nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought.
So that is Mr. Chikata in that exchange with several of the Supreme Court justices. What happens now, Joseph?
And so the court has set tomorrow for legal arguments on this particular issue as to whether or not, after the EC's lawyer has filed a witness statement, i.e. the chairperson of the Electoral Commission and that of the second respondent have put in a witness statement, whether they can elect that they are not going to have their witness go into the box to be cross-examined. And so there are supposed to be legal arguments advanced tomorrow on this issue.
Now, so this is tomorrow. We're going to get this clarity on this matter tomorrow.
Yes.
Okay, great. So I'm curious, though. I mean, after the sitting, we get reactions from both sides. Of course, in court, the side of the NPP didn't get to make their case. I think tomorrow they've asked to come and make
the
proper
legal
arguments.
Yes.
But we got some reactions from them.
Kojo Oppong-Nkrumah, who is chief spokesperson for President Akufo-Addo's legal team, he indicated to the court that he indicated to the pressmen after proceedings that as far as they are concerned, they are surprised that the petitioner is not happy that the respondents don't intend to provide witnesses to be cross-examined, because if they have a good case, then they should actually be happy. And so if they are not happy about it and they are actually going to argue that the EC chairperson and Mr. McMahon should go into the box to be cross-examined, it's evidence of the fact that the petitioners, in terms of the three witnesses that they've provided, they failed to lead evidence to show that none of the candidates that contested the 2020 elections got more than 50% of the vote cast. Neither have they been able to demonstrate that they are entitled to the relief they are asking the court to grant, i.e. order a runoff between the two individuals who got the most votes in the elections.
3. It is upon the completion of that the petitioner has now announced to the court that this is all that the case is about. And you heard Mr. Chikata say, "My lords, our case is closed." And His Lordship, the Chief Justice, say, "By court, the petitioner's case is closed." If we were in a criminal trial, what will happen now is that the court will have to determine whether or not a substantive case has been made, in which case the defendant or the defense may now raise an argument that maybe no case has even been made. So I don't even need to bother raising a defense in the first place. In a civil process, there are similar remedies. What you noticed happened, which is the second matter I'll speak about, is counsel for the first petitioner announced to the court that the evidence, counsel for the first respondent, I beg your pardon, announced to the court that the evidence that the petitioner has provided is enough, and the cross-examination that has taken place is enough, and that the first respondent does not intend to call witnesses to adduce evidence, any further evidence before the court. And counsel on the side of the second respondent has advertised same, because by now, whatever evidence that the petitioner has put before the court, once the case is closed, it is believed that they have brought all their evidence and they have made such a strong case. And so it should actually be to the disadvantage of the respondents if they say that they don't even intend to call witnesses to adduce evidence. But you notice that the petitioners are not too happy about it. They want literally to compel the respondents to bring in witnesses to, I don't know, adduce some evidence that may help the petitioner in his cause. The court has adjourned, as you heard, to tomorrow morning, and we'll listen to the legal arguments on both sides. We are very, very happy, extremely happy that the petitioner has come to the end of his case and has adduced all the evidence that he has. Evidence which is supposed to prove that nobody got 50%, that whether or not you add Techiman South, the winner will change. That Article 63.3 has been breached. This is all the evidence that they have, which they have made available. And we'll hear what the court says tomorrow as it proceeds to deal with the matter. Yes, sir.
On the line with me right now is Eduji Tamaklo. He's a member of the legal team for the NDC, and of course, he speaks too for the petitioner's case. Mr. Tamaklo, thank you for your time here on Top Story.
Good evening, and good evening to your listeners.
So we just had there, Mr. Oppong-Nkrumah said that, well, you've made your case, and they don't want to rebut it. with their witnesses in the box. That should make you happy. But it doesn't appear so. Why?
I wish I had the benefit of asking upon Kuma when was the last time he applied what he just said in the case that he handled himself. Look, let us not trivialize a very serious judicial review of the conduct of the chairperson of the Electoral Commission. There had been issues raised relative to her performance in connection with Article 23, in connection with Article 296, in connection with Article 63.3. These are matters that require evidence. It's a civil matter. Our burden is to prove this matter on the preponderance of probability. We have done that. In fact, counsel for the second petitioner has on several occasions admitted that they were in fact vote pardoned, except to say that the number of votes pardoned are not enough, as it were, to shake the results. Now, if I come to court and make a claim that you have pardoned votes, and your response is that, yes, it's true, votes have been pardoned, but they have been pardoned for both sides, it is only fair that the only person who did the pardon here, the returning officer, be made to explain how, under her constitutional or statutory responsibility, how she is able to pardon votes for the parties. Then you say, no, I don't think she should come. Meanwhile, you have filed an answer to the petition. When the petition was filed, and you think it was without merit, what do? You said in your answer that it discloses no cause of action. The court said, look, we are going at the end of the trial. And so when they were setting down the issues, one of the issues they set down is that, in fact, issue one is a determination whether or not the petition is closed. Now, when you knew that you have failed on that tangent, because now, instead of that application being taken so early, the court said, look, we will listen to both ends, all the story involving the 2020 election, and then we'll give consolidated decision. Now, from nowhere, you come out with this that, more or less, I am making a submission of no case. But the rule on submission of no case is very clear. I do not intend to put an argument that we intend to do tomorrow before you. In fact, I'm not permitted to do that. But what is clear is that the Electoral Commission and its chairperson is not just performing a trivial function. No. It is a constitutional function that only one person can perform. And that person is the chairperson. In fact,
but you have her witness. You have her witness statement. Isn't that enough?
You see, the respondents should even be interested in putting Jane in the witness box. In fact, the second respondent, to demonstrate that his legitimacy to continue to rule this republic flows from a flawless election. It even works in his own favor.
But isn't it clear why he won't do that? Because he believes it was flawless indeed, and there's no need for anybody else to make that point for them.
Already his lawyer under cross-examination had in fact admitted that votes were padded, except to say some, they are just 40, or this and they are just 400. If you do 400 all over, that's when you aggregate the wrongdoing. So in terms of the quantitative sense, if vote can be padded for any of the candidates, how can such an be deemed? And so it is only fair. It's only in the sense of justice that Jane Mensah is made to and lead evidence to the averment in her answer.
Yeah, but the question I ask you remains. I mean, you have Mr. Tamakulu, just a second. We'll come to that. If you can address this question briefly, because it's a simple one. You have the her witness statement before you. Isn't that enough? What will the cross-examination do?
You see, even you have been caught. You see, when a party puts its witness statements, that witness statement is not cross-examined upon. It's as good as hearsay. It's of no probative value.
Her lawyer says you can treat it as that if you prefer.
No, but you heard the court saying that at this point that is not what he's asking. And if, with respect, the witness statement is struck out, then it goes together with the answer.
But what
it means is that the things in the answer remain unproven. Then the petitioner succeeds.
But final question before I bring your colleague from the other side in. Mr. Tamaklo, you took this matter to court. You have made your case with 3 witnesses. Normally what happens when the defendants come in is to put in your own witness to try and further discredit your case. They say we don't want that because they argue that you haven't proven your case beyond any doubt at all, if that's the burden. And that's why they don't want to do so. Shouldn't that gladden you?
Evans, for the first time since 1992, at least you have had the benefit of policing by way of your journalist work some of our elections. Have you seen any election conducted where the chairperson of the Electoral Commission has made several declarations by way of what the valid vote cast is? You, as a journalist, it is even in your own interest that at least the chairperson mounts the witness box to provide in a very logical sequence how results collated in 275 constituencies, numbers, can generate different outcomes. That is what you do in any decent democracy. You journalists, you should even be interested in knowing that how come that on the 9th you did a declaration. The morning after the 9th, you came with a press release, gave a different set of figures. Subsequently, on your website, you gave different set of figures. When the petition was filed, and the petitioner indicated a certain number as the total valid vote cast, you quickly now use that figure as electoral commissioner.
Yeah, I mean, just hold on for me. Let me hold on for me briefly. Let me bring in your colleague from the other side, Nana Adwoa Adobe Asante. Madam Asante, thank you for your time here. Top story. I mean, we saw the first election petition case in the 2012 one. Afari-Gyan agreed to come into the box and indeed subjected himself also to the transparent process of being cross-examined and leading his own testimony on the matter. Today, not only is the EC chairperson indicating she wouldn't do it, the president, whom you represent, also says he won't. The Eduji Tamaklo insists it's not in the interest of justice there. You're not indeed making the process unanswerable and accountable to the people. Your reaction?
So good evening, Evans, and good evening to your listeners. I think it's very important from the onset to distinguish the court of law from the court of public opinion. There are many avenues in which if Ghanaians want some information from the EC, they can rightly do so. But this interest of juxtaposing the court of public opinion against the court of law is something that is still lost on me as to why there's the confusion, because this is a court of law. We have the petitioner has brought its case before the court. There is a fundamental principle that you have the right to be heard, but inherent in that right is the right not to speak. It is a privilege to speak and make your case or put your case across to the court, but it's not an obligation. And I think it's unfortunate that our colleagues on the other side are trying to milk this for the propaganda value. But the honest truth is there is the right to be heard, but that right to be heard has the inherent right not to speak.
Direct question. Are you afraid of the cross-examination and the strict proof that you'll be subjected to if you enter the box? Is that why you're, as Chachu said today, running away?
We are not running away. We are not evading. There are different strategies that a lawyer takes when pursuing a matter in court. And this is one of our arsenal. And we believe that this is actually the master stroke. We are happy with the way matters unfolded today in court, and we are ready to make legal arguments and justify to the court why we feel that this matter has come to an end. The petitioner has adduced evidence, and I think the petitioner should actually be happy, because if you've adduced evidence and you think your evidence is sufficient enough, you should not be relying on your opponent's evidence to further prove your case. No, you brought the matter to court. The burden of proof lay on you. As long as you have effectively discharged this burden, you should be happy that the petitioner, the first and second respondents are not even willing to put in evidence or adduce evidence to support their part of the case. It's our risk that we are willing to take, and I am still at sea as to why the petitioner is not happy with this. But as we have said from the beginning, there is a propaganda value to this petition, and we think that it is because of the propaganda value that the petitioner is upset with our strategy that we've decided to take.
Madam Adobe, I'm grateful. Edudzi Tamaklo, I'm grateful. Tomorrow, I'm pretty sure all the arguments will be laid before the court, and the decision will be made on this. You want to stay with us, because there's a lot more that happened before the court today that I'll bring to you, including the witness, the testimony of Rojo Metal Nunu. But again, this was Chachu's, main point today, which generated a fair bit of controversy on the floor on the matter that we've just been talking about.
And we are respectfully submitting that this witness cannot run away from cross-examination when they have elected. My Lord, when they have elected, that is the point. They have elected to the language, please. Oh, my Lord, maybe you can my Lord, but run away. My Lord, it is being a telecast, and people may interpret it. I will adopt your words. If your Lordship, he's evading. My Lord, I will totally adopt your Lordship. I will totally. Yeah.
55, 78, 58, 70. Hey, Charlie, my network is really killing me. I have to pay my uncle's workers via mobile money, but the charges alone, it's about 380 cedis. Charges alone just to send money? That's $10 of cement already, my guy. Listen, bro, you can save money on charges if you move to Vodafone Cash now. Vodafone Cash? But my network is... Hey, sending money on that your network, you pay. Sending